Pleasant day to each and everyone. We are the group 4, so we're going to discuss with you the appellate jurisdiction, the Papa versus Mago, and lastly, the what we call this territorial jurisdiction. So first off, we commonly know that jurisdiction is a legal way of making decision and judgment with a judge presiding on it. So the appellate jurisdiction, from its word applicate, it's to appeal. And here's what the appellate jurisdiction means. It refers to the power of a court to hear appeals from lower courts, the power to review, revise, reverse, modify, or affirm final judgments and others of the lower courts. Basically, this one is being escalated to the higher courts, or we usually know this as the Supreme Court. So the original jurisdiction versus the appellate jurisdiction is the original jurisdiction is first court to hear the case, whereas appellate jurisdiction refers to the power to review the decision of the courts that have already issued rulings in a given case. So basically, the original jurisdiction is the first step or ang kinunhan yun nga gibuhat nga gi-preside siya o judge. So basically, wa man na satisfy ang ming appeal. So wa man na satisfy ang isa ka party sa decision sa kinunang courts or the lower court muna mi-appeal siya into the higher court. So the Court of Appeal is highly specialized body specifically created by Republic Act number 1125 as amended for the purpose of reviewing tax and custom cases. The CTA is, by the bare nature of its function, dedicated exclusively to the studies and consideration of tax problems. So basically, wala na siya ganang sila gid ang mga supervisor if siya na to sa BPO nga i-escalate ang isa ka issue. So they are the one to investigate the cases if unsa gyud nahitabuan ni sakto ba ang decision gibuhat sa taga lower court nganong nga na ang reaction sa isa ka party nganong wa siya may agree. So for sa further investigation gud mostly sa cases nga gireklamo sa isa ka party. So the CTA is composed of presiding judge and 8 associate justices, each of whom is appointed by the President of the Philippines upon the nomination by the Judicial and Bar Council. So the CTA jurisdiction over the following is first the exclusive jurisdiction, which is the kanang istoryahan to ganina, pero kani siya is exclusive yun na siya. So it is a jurisdiction over criminal cases arising from violation of National Internal Revenue Code, NIRC, and the Tariff and Customs Code, now CMTA, and other laws administered by the BIR and the POC, where the principal amount of taxes and fees exclusive of charges and penalties claim is 1 million pesos and above. So basically, kani siya is ang most cases niya is more on the tax and the tariff. So makita na to ang NIRC dire o CMTA, and napaisa condition it is charges and penalties claim di siya mula pa siya og 1 million. So naputay case nga anang wala siya kaabot og kanang 1 million, which is the exclusive appellate jurisdiction over violations of NIRC and CMTA and other laws administered by BIR and BOC decided by the regular court, where the principal amount of tax and fees is less than 1 million. So wala na siya kanang pinabali sa exclusive original jurisdiction. Kaya siya gitawag na siya og exclusive appellate jurisdiction over violations of NRC and CMTA. So exclusive appellate jurisdiction over the decision of the commissioner, customs involving liability and customs duties, fees or other money charges, seizure, detention, or release of property affected, fines, forfeitures, or other penalties in relation thereto, or other matters arising under the custom laws or other law administered by the Bureau of Customs. So basically mo ni ang ming appeal na ang cases nila is katong mga seizure, detention, release of property, fines for discharge of pa. So guys, dili lang nato kayo libubon tong kagalingon nga kaning kuan appellate jurisdiction is simply appealing to revise or reinvestigate cases nga wala may approve ang isa ka party munang nadungsa sa higher court or Supreme Court. So the fourth one is the exclusive appellate jurisdiction over a decision of the Secretary of Finance on custom cases elevated to him automatically for review for decision of Commissioner of Customs which are adverse to government under Section 1127 of CMTA. So kaning Section 1127 of CMTA muna siya ang evaluate ni Commissioner ang decision ni District Collector ba to nga naka-adverse siya sa government. So mingon tag-adverse it is unfavorable or kanang disadvantaged kayo ang gobyerno ani. So it's the same way nga kaning decision ni Commissioner i-review na pud ni Secretary of Finance nga mo gi-appeal ni sa ka party kay wa siya minguyon. So lastly, the exclusive appellate jurisdiction over decision of Secretary of Trade and Industry in cases of non-agricultural commodity or goods, and the Secretary of Agriculture in cases of agricultural product, commodity, or goods involving dumping and countervailing duties under Section 711 and 713 of the CMTA and safeguard measures under RA 8800 or Section 170 of CMTA. So kani siya is a appellate jurisdiction nga i-decide if non-agricultural siya ato siya mahog ni Secretary of Trade and Industry, and if sakop siya sa agricultural product ato po siya ni Secretary of Agriculture. So basically the 711, the 713 is the countervailing and the Anti-Dumping Act. So we all know that Anti-Dumping Act is implemented with the intent of protecting domestic markets when foreign country dumps good domestic markets with lesser price. So basically, we all know in the basic math that we usually use, we usually buy the cheaper ones in order for us to save or kanang mas makalesta, and we have i-save money para mo pay gamitan sa isa ka butang. So basically sa kani nga scenario is that we are affected once gani nga ang foreign countries mohatag o kanang ingana kanang goods nga mas lower or price sa ato pa ang domestic products dakong posibilidad nga di siya mahalin. So na siya duha ka impact. It's called the trade balance. It is we suffer deficient and balance of payment. Kay along the way, if although may levied man tag taxes sa mga gipang export gikan nato, pero the question is dili gyud siya, is it really enough nga i-compensate nato ang mga kuan? Kay most of the time we all know that exportation is the majority of the profit is ato gid mismo sa export. So munang aside from that, in the trade balance mo sakasad ang atong debts kay we're unable to compensate the domestic profit man. So which means da ang atong mga domestic markets dili na sila mahalinan, and later on babankrupt sila or manira. So all responsibility sa government nga mangita gyud fund unsaon nila pag-establish sa ilang projects or unsaon nila pag-regulate sa mga balaod nga ilang ipangbugna, just like the tax. You know that the tax is being tax is one of the regulatory or one of the ways nga ma-regulate nato ang mga acts nga atong gimo. Example of which is the sin tax. So ipatuyo nga dako ang tax sa cigarettes, alcoholic kay makadaot man na siya, at the same time gidiscourage siya nato ang mga consumer nga dili mo palit ana. So kani silang 711 o 713 known as the anti-dumping and the countervailing is simply filling the gaps of the what you call this kanang lower price. Ito pa og lower price ani na si countervailing of anti-dumping acts, anti-dumping kuan na mo compensate aron ma-equal siya sa fair value sa market. Let's say or na siya, let's say for example 3C ang kuan what do you call this kanang chicherya, then ang chicherya sa gikan sa export is tag 10 ra. So mag-charge og 3 or ma-equal sila sa kanang product nga nato may mo siyang 3C munang napay possibility nga mamili na sila depende na lang gyud sa quality. So mo na rason nga nang naing ana. So the safeguard measure under RA 8800 also known as section 712 of CMTA is simply prohibiting the products nga musod sa atong country. So ibuhat na siya para mas mutaas atong level of quota nga nang i-prevent nato siya is because or mahalin ang atong product nga domestic. Okay? So I think that's all for me and I'll pass you to the next report. Thank you so much.
Hello everyone, I am Gina Maurice Villaganas, and before we proceed to the case of Papa versus Mago, I should first discuss the proceedings involved in the case. Section 1137, Exclusive Jurisdiction of the Bureau. Jurisdiction over imported goods and goods for exportation shall be exclusive to the Bureau or the Secretary of Finance when under review by the latter, subject to the proceedings described in this title. Except for the CTA, no court may issue any order or decision until all the remedies for administrative appeal have been exhausted. So, once the goods are imported or exported here in Philippines, the Bureau automatically acquires exclusive jurisdiction over the goods. And if the goods are under review or is subject to proceedings because of some sort of issues like undervalued and misdeclaration of the goods, then no other court may interfere during the proceedings of the Bureau except the CTA. Next is relevant doctrines in customs proceeding. The doctrine of primary jurisdiction requires that a party should first seek relief in an administrative proceeding before he seeks remedy in court. So if you guys remember, di ba last time gipahimutan ni Ma'am Liken og process of remedies of an importer or exporter pertaining to dispute settlement or protest. And 'di ba after i-lodge sa importer or exporter ang goods is the customs officer tasked to verify the documents, the accuracy of the documents, and if the importer or exporter does not agree with the reclassification of the customs officer, then he should evaluate the matter to the principal appraiser, and then after that to the chief, and then formal division unit, and then to the deputy collector for assessment, and finally to the district collector. And if dili gyapon siya agree sa decision sa district collector, then he can file an appeal to the Commissioner of Customs. And if dili gyapon gid siya kanang agree sa decision sa Commissioner of Customs, then ay sa pa siya pwede mo file og appeal adto sa CTA, which is part of judicial proceedings. So before ang importer ug exporter gyud mo adto sa CTA, dapat moagi pa gyud siya sa administrative proceedings sa customs. Dili siya pwede mo diretso lang sa CTA because because na may process ang pag-file og remedies. Next is the doctrine of exclusive jurisdiction. So, states to the effect that once an administrative body takes cognizance of a controversy, no other court or body must interfere in the resolution of such controversy. Otherwise stated, it is the power of the Bureau of Customs to adjudicate a case or institute a proceeding to the exclusion of all other courts of bodies. So, doctrine of exclusive jurisdiction. So, once na nasa control sa Bureau of Customs ang goods, is ang Bureau naka-acquire na og exclusive jurisdictions. So, no other court or body must interfere the resolution of the controversy. And if during the process of the proceedings, once nga naay mo interfere na court, then naay power ang customs na mo adjudicate sa case or mo make siya decision based sa iyang ruling. It can be stated that the Bureau of Customs acquired exclusive jurisdiction over imported goods for the purpose of the enforcement of the customs law from the moment the goods are actually in its possession or control, even if no warrant of seizure or detention had previously been issued by the collector of customs. Primary jurisdiction is vested in seizures and forfeiture proceedings in the collector and the commissioner or the customs to the exclusion of the regular court. So once nga naa na sa possession or control sa bureau ang goods, then even if wala siya warrant of seizure or detention, pwede ma-seize sa customs ang goods because according to the Tariff and Customs Code, the warrant of seizure or detention is not needed in the instant case. So the last doctrine in customs proceedings is the doctrine of exhaustion of administrative remedies. So states to the effect that before a party is allowed to seek intervention of courts, it is a precondition that he should have availed of all the means of administrative processes afforded him. Hence, if a remedy within the administrative machinery can still be resorted to by giving the administrative officer every opportunity to decide on the matter that comes within his jurisdiction, then such remedy should be exhausted first before the court's judicial power can be sought. If a party prematurely invokes the court intervention, then such premature intervention is fatal to his cause of action. It is a ground for dismissal of his action. The remedy of the owner or the importer in case of dissatisfaction with the decision of the collector of customs is to appeal before the commissioner of customs all the way to the Court of Tax Appeals. So like sa gingon ako ganihan na before ang importer or exporter mo seek og relief sa court, naa siya'y dapat agian na proceedings. So dapat mag-una siya sa administrative proceedings like moagi siya daan sa pinakaubos like customs officer. And then after the customs officer, pwede siya moadto din sa district collector, and if dili pa gid siya mo-agree sa decision sa district collector, then pwede siya mo-appeal sa commissioner. And if dili gyapon siya mo-agree sa decision sa commissioner, then aysa pa siya pwede mo seek og relief sa court, which is the CTA or Court of Tax Appeals. Kay if once na ay court na mo interfere during the process of the Bureau of Customs, then naay power ang customs to make a decision. So pwede niya ma-forfeit ang goods, which is not good for the importer. So dapat ang importer-exporter is musunod gid sa process sa administrative remedies aysa sila mo seek og relief sa court.
Relevant case rulings. The Collector of Customs, when sitting in seizure and forfeiture proceeding, has exclusive jurisdiction to hear and determine all questions touching on the seizure and forfeiture of dutiable goods. The regional trial court are precluded from assuming cognizance over such matters. Next, we have the exclusive jurisdiction of the Collector of Customs cannot be interfered with by regular courts even upon the allegation of ownerships. It is settled rule, therefore, that the Bureau of Customs acquires exclusive jurisdiction over imported goods for the purpose of enforcement of customs laws from the moment the goods are actually in its possession and control, even if no warrant of seizure or detention have previously been issued by the Collector of Customs in connection with seizure and forfeiture proceedings. Petitioners: Martin Alagao, Head of the Counterintelligence Unit of Manila Police Department; Ricardo Papa, Chief of Police of Manila and a duly deputized agent of Bureau of Customs; Jacinto Gavino, Customs Commissioner; Juan Ponce Enrile, Customs Commissioner, and Pedro Pasis, Collector of Customs of the Port of Manila. Plaintiffs: Remedios Mago, owner of the goods; Valentina B. Lanopa, owner of the trucks; Judge Hilarion Harencio, presiding judge of Branch 23 Court of First Instance of Manila. Papa versus Mago, a case about the 9 bales of goods that were seized at Agrifinas Circle, Ermita, Manila. Important dates: November 3, 1966, received an information of allegedly released of misdeclared and undervalued goods. November 4, 1966, seized of the 2 trucks. November 9, 1966, filed with the Court of First Instance of Manila a petition for mandamus with restraining order or preliminary injunction docket as civil case number 67496. November 10, 1966, Judge Hilarion Harencio issued an ex parte restraining the respondents in civil case number 67496. November 15, 1966, Remedios Mago filed an amended petition in civil case number 67496, including a party defendants Collector of Customs Pedro Pasis of the Port of Manila and Lieutenant Martin Alagao of the Manila Police Department. November 16, 1966, hearing of the petition for preliminary injunction. November 24, 1966, filed their answer with opposition to the issuance of the writ of preliminary injunction. December 9, 1966, hearing on the lower court, ordered that an inventory of the goods be made by its clerk of court in the presence of representatives of the claimant of the goods, the Bureau of Customs, and Anti-Smuggling Center of Manila Police Department. December 13, 1966, the above named persons filed compliance itemizing the contents of the 9 bales. December 23, 1966, Remedios Mago filed an ex parte motion to release the goods. January 1967, supplemental opposition was filed by defendants alleging that on January 12, 1967, seizure proceedings against the goods have been constituted by the Collector of Customs of the Port of Manila, and the determination of all questions affecting the disposal of property proceeded against the seizure and forfeiture proceedings should thereby be left to the Collector of Customs. January 30, 1967, defendants filed a manifestation that the estimated duties, taxes, and other charges due on the goods amounted to 95,772 pesos. February 2, 1967, Plaintiff Remedios Mago filed an urgent manifestation and reiteration of the motion of the release under bond of the goods. March 7, 1967, the respondent judge issued an order releasing the goods to herein Plaintiff Remedios Mago upon her filing of a bond in amount of 40,000 pesos. On March 13, 1967, said plaintiff filed the corresponding bond. March 13, 1967, Ricardo Papa, on his own behalf, filed a motion for reconsideration of the order of the court releasing the goods under bond. On March 30, 1967, restraining respondent judge from executing, enforcing, or implementing his order on March 7, 1967, in civil case number 67496 of the Court of First Instance of Manila, and from proceeding in any matter in the said case.
So the case filed in the Papa versus Mago case during the first jurisdiction, Mago and Lanupan filed with the Court of First Instance (CFI) of Manila a petition for mandamus with restraining order or preliminary injunction, civil case 62496. So this is the main case filed of Mago, the owner of the goods. So she claimed that the goods were seized by a member of the Manila Police Department without any search warrant issued by a competent court. So that's why she filed a petition for mandamus in the CFI. So next is Remedios Mago filed an amended petition in civil case number 62496, including as party defendants District Collector of Customs Pedro Pacis of the Port of Manila and Lieutenant Martin Alagao of the Manila Police Department. So after niya mag-file og first case katong for petition for mandamus is nag-file na pud siya amended petition na i-appeal na niya as defendants ang Collector of Customs, which is si Pedro Pacis, and Lieutenant Martin Alagao of the Manila Police Department, which is ang ni-seize sa goods. The next is Remedios Mago filed an ex parte motion to release the goods. And lastly is respondents filed their opposition to the motion. So after mag-file ni Remedios Mago og ex parte motion para ma-release ang goods is ni-file ko the mga respondents na mo-oppose sa gi-file ni Remedios Mago because according to the customs na dili pwede ma-release ang goods because the First Instance of Manila has no jurisdiction over the case because the goods are under the Bureau of Customs. So the Bureau acquires exclusive jurisdiction over the goods. That's why the First Instance of Manila has no jurisdiction over the case. So without waiting the decision of the court, so si Papa or the Commissioner of Customs filed a motion for reconsideration, filed the action for prohibition and certiorari with preliminary injunction before the Supreme Court.
Facts. Petitioner Martin Alagao, head of the Counterintelligence Unit of the Manila Police Department, acting upon a reliable information received on November 3, 1966 to the effect that a certain shipment of personnel effects allegedly misdeclared and undervalued would be released the following day from the customs zones of the Port of Manila and loaded on 2 trucks, and upon orders of Petitioner Ricardo Papa, Chief of Police of Manila, and a duly deputized agent of the Bureau of Customs, conducted surveillance at gate number 1 at 4:30 in the afternoon of November 4, 1966. Elements of the counterintelligence unit went after the trucks and intercepted them at the Agrifina Circle, Ermita, Manila. The load of the 2 trucks, consisting of 9 bales of goods, and the 2 trucks were seized in instructions of the Chief of Police. Upon investigation, a person claimed ownership of the goods and showed to the policeman a statement of receipts of deputies of duties collected in informal entry number 1475501, issued by the Bureau of Customs in the name of certain Bienvenido Nugget.
So, issue on original jurisdiction. First is that the goods were seized by the members of Manila Police Department without search warrant issued by a competent court. Next, that the Manila Chief of Police Ricardo Papa denied the request of counsel for Remedios Mago that the bales be not opened and the goods contained therein be not examined. Next, that then Customs Commissioner Jacinto Gavino had illegally assigned appraisers to examine the goods because the goods were no longer under the control and supervision of the Commissioner of Customs. Lastly, that the goods, even assuming them to have been misdeclared and undervalued, were not subject to seizure under Section 2531 of the Tariff and Customs Code because Remedios Mago had bought them from another person. So the held to the main issue is Petitioner Martin Alagao and his companion policemen had authority to effect the seizure without any search warrant issued by a competent court. So meaning katong pag-seize sa mga policemen is valid bisan pag wala sila search warrant issued by a competent court because the Tariff and Customs Code does not require the said warrant in the instant case. So it cannot be doubted therefore that Petitioner Martin Alagao and his companion policemen has authority to seize the goods without any search warrant issued by a competent court. So the second issue is that the Manila Chief of Police Ricardo Papa denied the request of counsel for Remedios Mago that the bales be not opened and the goods contained therein be not examined. So the held is that the Chief of Manila Police Department, Ricardo G. Papa, having deputized in writing by the Commissioner of Customs, could lawfully open and examine any box, trunk, envelope, or other container wherever found when he had reasonable cause to suspect the presence therein of dutiable articles introduced into the Philippines contrary to law. And since Chief of the Manila Police Department Ricardo G. Papa has been authorized by the Commissioner of Customs, then naa siya right na mo-open or ma-examine sa box or trunk, envelope, or any other container. So, at the case of Remedios Mago, since authorized si Ricardo G. Papa, so pwede niya ma-open ang bills regardless sa request ni Remedios Mago. That then Customs Commissioner Jacinto Gavino had illegally assigned appraisers to examine the goods were no longer under the control and supervision of the Commissioner of Customs. So, sa anina case is, the Bureau of Customs had not lost jurisdiction over the goods since si Remedios Mago had not fully paid the duties and charges, then the goods is still on the jurisdiction of the customs. As long as the importation has not been terminated, the goods remain under the jurisdiction of the Bureau of Customs. Since Remedios Mago did not fully pay the duties and charges, then the Bureau of Customs acquired the jurisdiction of the goods. So, mawala lang ang control sa Bureau of Customs sa good once na the duties and taxes are fully paid. So, the last issue is that the goods, even assuming them to have been misdeclared and undervalued, were not subject to seizure under Section 2531 of the Tariff and Customs Code because Remedios Mago had bought them from another person. So, in this case, contrary to what she claimed that the goods were purchased from Santa Monica Grocery in San Fernando, Pampanga, it is actually were imported from Hong Kong as shown in the Statement of Receipts. Statement and receipts of duties collected on informal entry, and that most of the goods as shown in the inventory were not declared, presumably to avoid the payment of the duties, and were therefore subject to seizure and forfeiture. So next is the issue on appellate jurisdiction. First is the Court of First Instance Manila, presided by respondent judge, had no jurisdiction over the case. Respondent Remedios Mago had no cause of action in civil case number 67496 of the Court of Instance of Manila due to her failure to exhaust all administrative remedies before invoking judicial intervention. And lastly is the bond fixed by respondent judge for the release of the goods was grossly insufficient. So the held on appellate jurisdiction is number 1, the Court of First Instance of Manila presided by judge had no jurisdiction over the goods. So the held is the goods in question were under the custody and at the disposal of the Bureau of Customs at the time the petition for mandamus. The Court of First Instance of Manila, therefore, could not exercise jurisdiction over said goods even if the warrant of seizure and detention of the goods for the purposes of the seizure and forfeiture proceeding had not yet been issued by the Collector of Customs. So, like sa gidiscuss nato ganiha na since ang goods is under the exclusive jurisdiction of the Bureau, then the Court of First Instance of Manila has no jurisdiction over the case. So the Court of First of Instance Manila should not interfere. Second is, Respondent Remedios Mago had no cause of action in civil case number 67496 of the Court of First Instance of Manila due to her failure to exhaust all administrative remedies before invoking judicial intervention. So the held is Remedios Mago was not entitled to the main reliefs she prayed for because the doctrine in customs proceeding requires that the party should first seek relief in an administrative proceeding before he seeks remedy in court. So, like diniha the doctrine in primary jurisdiction na importer should first seek relief in an administrative proceeding before he seeks remedy in court. So, si Remedios Mago is wala siya nisunod sa process na first, dapat mo seek gid siya relief daan sa administrative proceeding like moagi daan sa customs officer and then after customs officer is to the principal appraiser. Then to the district collector. After the district collector is pwede na siya mo appeal to the commissioner of customs. Then if dili gyapon siya agree sa decision sa customs commissioner, then ay sa pa siya mo seek og relief sa court, which is wala niya gibuhat, didiretso dayon siya sa court, which is the Court of First Instance of Manila. Then lastly is the bond fixed by respondent judge for the release of the goods was grossly insufficient. So the estimated duties and taxes and other charges on the goods subject of this case amounted to 95,772 pesos as evidenced by the report of the appraiser of the Bureau of Customs, but Remedios Mago filed a bond in the amount of 40,000 pesos only. So kulang kaayo ang gi-fix ni respondent judge nga bond para ma-release ang goods ni Remedios Mago. So here is the judgment of the Appellate Court. So mao ni ang decision sa Supreme Court. A. Granting the writ of certiorari and prohibition prayed for by the petitioner. Then letter B. Declaring null and void for having been issued without jurisdiction the order of Respondent Judge Hilarion U. Harenshaw dated March 7, 1967 in Civil Code number 67496 of the Court of First Instance of Manila. C. Declaring permanent the preliminary injunction issued by this court on March 31, 1967, restraining respondent judge from executing, enforcing, and/or implementing his order of March 7, 1967 in Civil Case number 67496 of the Court of First Instance of Manila and from proceeding in any manner in said case. D. Ordering the dismissal of Civil Case number 67496 of the Court of First Instance of Manila. And lastly is ordering the private respondent Remedios Mago to pay the cost.
Territorial Jurisdiction for the due and effective exercise of the powers conferred by law, and to the extent requisite therefore, said, Bureau shall have the right of supervision and police authority over all seas within the jurisdiction of the Philippines, and over all coasts, ports, airports, harbors, bays, rivers, and inland waters navigable from the sea. When a vessel becomes subject to seizure by reason of an act done in Philippine waters, in violation of the tariff and customs laws, a pursuit of such vessel begun within the jurisdictional waters may continue beyond the maritime zone, and the vessel may be seized on the high sea. Imported articles which may be subject to seizure for violation of the tariff and customs laws may be pursued in their transportation in the Philippines by land, water, or air, and such jurisdiction exerted over it at any place therein as may be necessary for the due enforcement of the law. In territorial jurisdiction, Bureau have the right of supervision and also the police authority to seize the goods inside the territorial jurisdiction of the Philippines. It can be over all coast, ports, airports, harbors, bays, rivers, and inland waters that navigable from the sea. So if there's a good nga moabot sa Philippines na ay katungod ang bureau nga isis ang goods. In Section 300, Customs Jurisdiction, it is related to the territorial jurisdiction in the Philippines. For the effective implementation of this act, the Bureau shall exercise jurisdiction over all seas within Philippine territory on all coasts, ports, airports, harbors, bays, rivers, and inland waters, whether navigable or not from the sea, and any means of conveyance. So the Bureau shall pursue imported goods subject to seizure during its transport by land, water, and air, and shall exercise jurisdiction as may be necessary for the effective enforcement of this act. When a vessel or aircraft becomes subject to seizure for violation of this act, a pursuit of such vessel or aircraft which began within the territorial water or airspace may continue beyond the same, and the vessel or aircraft may be seized in the high seas or international airspace, basta ka-under siya sa territory of the Philippines. Then, jurisdiction of the Bureau of Customs. The jurisdiction of the Bureau of Customs within the Philippine territory shall include coasts, ports, airports, harbors, bays, rivers, and inland waters. Then, the extent of Philippine territory as provided under Article 1 of the 1987 Constitution comprises the Philippine Archipelago with all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and surreal domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. Then the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. Doctrine of hot pursuit, where imported goods may be pursued during their transport by land, water, and air, or where a vessel or aircraft subject to seizure for violation of the CMTA or Customs Modernization and Tariff Act within the territorial waters or airspace of the Philippines may be seized in the high seas of international airspace. If na-adjud kay violation nga nahitabo sa pag-import sa goods, then kana siya subject to seizure jud na. Dapat aware ta nga ang atong goods nga i-ship or gi-import kuan legal na siya para dili na siya masisa Bureau of Customs or the Bureau nga tao sa Bureau nga naay rights nga mo sa mga goods.
Hi ma'am, I'm Marinel Castañeras and my topic is about Section 301 Customs Control over Goods. So what is in Section 301? Customs control over goods. All goods, including means of transport, entering or leaving the customs territory, regardless of whether they are liable to duties and taxes, shall be subject to customs control to ensure compliance with this act. In the application of customs control, the Bureau shall employ audit-based controls and risk management systems, use automation, to the fullest extent possible and adopt a compliance measurement strategy to support risk management. The Bureau shall seek to cooperate and conclude mutual administrative assistance agreements with other customs administrations to enhance customs control. The Bureau shall consult, coordinate, and cooperate with other government regulatory agencies, free zone authorities, and the customs stakeholders in general to enhance customs control. So, the power of control. The Bureau's power of control over goods includes subjecting all goods, including means of transport, entering or leaving the customs territory, regardless of whether liable for duties and taxes, under customs control to ensure compliance with CMTA. Towards this end, the Bureau is mandated to employ audit-based controls and risk management systems, use automation to the fullest extent possible, adopt a compliance measurement strategy to support risk management, cooperate and conclude mutual administrative assistance agreements with other customs administrations to enhance customs control, consult, coordinate, and cooperate with other government regulatory agencies, free zone authorities, and customs stakeholders. So, what is customs control? Customs control, they have the power to execute specific actions. These include controls on duties to be paid, and taxes, and the correct classification of the goods, their origin and value, the security and safety requirements, counterfeited products, fight against terrorism, smuggling, and etc. Compliance with environmental legislation, application of health requirements, veterinary, phytosanitary, and quality regulations. So, how do customs do that? Customs may examine goods, take samples, verify the accuracy and completeness of the information, and authenticity, accuracy, and validity of the documents. Examine the documents of economic operators and other records. Inspect means of transport, carry out official inquiries, and perform other acts. Sa Section 301, ang customs has the power of control of overall goods, and it includes the means of transport. For example, the goods is inside the vessel, aircraft, and it is entering or leaving the customs territory. Regardless whether or not it is liable to duties and taxes, all of these goods is subject to the customs control. So, ang isa ka goods, before ni siya mo enter or leave the country, regardless nga liable ba ni siya sa duties or taxes, kinanglan pa jud una nga moagi siya sa process sa customs control. Kailangan pa ang taga-customs ang kaning specified nga goods ma-check pa una, ma-examine pa una, o usa pa sila ma-release kung ma-verify na nga kani nga goods kay ga-follow sa customs laws o wala sila na violate. To make sure that the said goods are examined and had the records of the authenticity of the documents. In application of this control, the Bureau should employ audit-based control and risk management system. So, what is audit-based control? It means measures by which the customs satisfy themselves as to the accuracy and authenticity of declarations through the examination of the relevant books, records, business systems, and commercial data held by persons concerned. Ang kaning risk-based management system, members must undertake the implementation of a risk-based management system for carrying out customs controls on all imports, exports, and transit transactions. Customs administrations are required to systematically apply risk management principles to ease the release of goods while at the same time ensuring the safety of the released merchandise. Ang Bureau of Customs, they should be using an automated system where they can see and monitor the entrance and the clearance of vessel and the goods of it and the goods inside of it to the fullest extent possible. Kinanglan ang taga-customs na ma-monitor po nila ang goods. They should be adopting a compliance measurement strategy to support the risk management. As of this moment, the Bureau of Customs is already using an online transactions or online monitoring of the goods entering and leaving the country. In Section 301, the Customs may also seek help from the government agencies for them to be able to perform their mandate at the most. Because the Bureau of Customs cannot work on by itself because there are a lot of goods and commodities that are subject to regulation by other agencies, so the Bureau of Customs need help or need to cooperate or consult from that certain agency for the clearance of those particular goods. Here are some of examples sa mga government agencies. DTI, the Department of Trade and Industry, Department of Agriculture, Department of Foreign Affairs, Department of Interior and Local Government, Department of Labor and Employment, and many more. Sa free zones, the Philippines Free Trade Zones are governed by the Philippines Economic Zone Authority or PEZA, which is a part of the DTI. Free Trade Zones in the Philippines: Freeport Area of Bataan, Clark Freeport and Special Economic Zone, Cagayan Special Economic Zone and Freeport, Cavite Export Processing Zone, Subic Special Economic and Freeport Zone, and San Carlos Eco-Zone. Ang Bureau of Customs, they shall monitor the entrance and exit of the goods to and from the country.
Good day, ma'am. My name is Onel Estusian. I'm going to report the Section 302 of the CMTA. So, Section 302. Enforcement of Port Regulation of the Bureau of Quarantine. Customs official and employees shall cooperate with the quarantine authorities in the enforcement of the port quarantine regulations promulgated by the Bureau of Quarantine and shall give effect to the same insofar as connected with matters of shipping and navigation. So, the Section 302 tell us that the Bureau of Customs should be asking help from the Bureau of Quarantine. So, since the shipping and the navigation is connected. So, example of this, ma'am, when there is goods. So, not only the Bureau of Customs ang mo inspect, but also the Bureau of Quarantine para ila-inspect if the goods are safe to be consumed by the Filipinos o safe ba ni sa Philippines. Isod sa Philippines, ibaligya. Thank you, ma'am. So, move. Section 303. Control over premises used for customs purposes. The Bureau shall, for customs purposes, have exclusive control, direction, and management of custom offices, facilities, warehouse, ports, airports, wharves, infrastructure, and other premises in the custom districts. In all cases, without prejudice to the general police powers of the local government units LGU, the Philippine Coast Guard, and the law enforcement agencies in the exercise of their respective functions. So, Section 303 of the CMTE just tell us that the Bureau of Customs has the control over all the places outside its office. So, example of this, a certain facility or a port or airport. So, every port or airport na sila management. So, ang management ani nila under gyapon ni sila sa Bureau of Customs. Ani nga section gipakita og unsa ka wide og unsa ka powerful ang Bureau of Customs in the goods and in the facility also. Thank you, ma'am.
Good morning, everyone. I am Justin Malaveras. I will be tackled about
Section 304, power of the President to subject premises to customs jurisdiction. When the public interest requires, the President may executive order declared any public wharf, landing place, infrastructure, strait, or land in any kinds of port of entry under the jurisdictions of the Bureau. It may be necessary for customs purposes to authorize a port to transfer an overstaying cargoes in an inland depot. With the approved executive order by the President nga nagpamatuod nga pwede i-transfer or i-release ang isa ka cargo nga nag-overstayed na siya sa isa ka warehouse kay kini mahimo bisan pag-asa nga warehouse as long as nasud ni sila sa premises of jurisdiction of the Bureau. The President is empowered to declare any places as part of customs jurisdiction, subject to the following conditions: is the place required by the public interest, a declaration through executive order, a place is necessary for customs purposes. Section 305, trespass or obstructions of customs premises. No person shall enter or obstruct a customs office, warehouse, port of entry, wharf, or other premises under the control of the Bureau without the prior authority, including the streets or alleys where these faculties are located. Kung ikaw isa ka unauthorized personnel nga nidong sa port of entry nga restricted nga wa kay dala nga kuan kanang permits or documentation nga nagpamatuod nga ikaw mudong anang lugar or authorized ba ka nga pagka personnel, pwede ka kasuhan og trespassing or obstructions of customs premises kay wala man kay possible nga documentation nga ikahatag nga nagpamatuod nga authorized personnel ka sa customs. Kay ang isa ka authorized personnel ra ang pwede ra makasulod sa isa ka restricted zone is the importer or the customs broker or other personnel nga authorized man gani dira anha nga lugar.
Now, we go on to Section 306 of Customs Jurisdiction and Customs Control. Special surveillance for the protection of customs revenue and prevention of smuggling. The Bureau shall conduct surveillance on vessels or aircrafts entering Philippine territory and on imported goods entering the customs office, provided to the function of the Philippine Coast Guard to prevent and suppress the illegal entry of these goods, smuggling and other forms of customs fraud, and violations of maritime law and its proper surveillance of vessels entering and or leaving Philippine territory, as provided in Republic Act No. 1993, otherwise known as the Philippine Coast Guard Law of 2009, shall continue to be enforced. Special surveillance. As part of its police authority, the Bureau of Customs shall conduct special surveillance on vessels or aircrafts entering the Philippine territory as well as on imported goods being entered at the customs districts. Inasmuch as the law recognizes the authority of the Bureau of Customs, the CMTA also recognizes the function of the Philippine Coast Guard under the Philippine Coast Guard Law. Section 307. Temporary storage of goods. Subject to the rules and regulation to be issued by the Secretary of Finance, the Commissioner shall establish a system for temporary storage of imports prior to goods declaration in case of abandoned or overstaying goods. As we review, Section 306 is about conducting special surveillance on goods that is entered or leaving the Philippine territory that is done by the Customs and the Philippine Coast Guard. That is to prevent illegal entry of goods, smuggling, and other forms of customs fraud. Also, Section 307 is about abandoned or overstaying goods, unclaimed goods, robbing certificate issues that are issued by Secretary of Finance therefore are subject to temporary storage of goods that is established by the Commissioner.
And that's all, guys. Thank you for listening. We do hope that you guys learned something from our report.